want to welcome everybody. This is Paul Hitchcock. Thanks for being here. And you got to see a little bit of the background of us getting prepared here. This is a great topic. I've got a couple of excellent guests here. I have Vistage Chair Jeffrey Bauer, who is doing some great things with his groups. We'll hear about those just here in a second. And Brad Barth is a partner with the asset protection, estate planning, and business planning firm Barth Caldwell. Actually, there's the headquarter building there in Southern California with clients across the country. Brad's one of our top speakers at the firm. Very high demand, speaking to Vistage and many other groups, and this is a very hot topic. We're very busy at the firm dealing with this Corporate Transparency Act, which you'll learn about here in a minute. And so, Jeffrey, I want to start with you and love to ask a few questions about Vistage in the groups that you're running over there. What type of groups do you have?
Okay, great. Thank you. Hello, everybody. I've been a Vistage chair about 5 years. I have 4 different groups. 2 of them are chief executive groups. My target audience in those groups are businesses with anywhere up to a couple of $100 million in revenue. The mean size of my groups right now is about 28 million. I have a key advisory group. The key group are people that report into the CEO or business owner. And I have a trusted advisor group who are service providers to the same type of businesses that I look to work with.
And Jeffrey, do you have available slots in any of your groups? And are you looking for anybody in particular?
Absolutely. I definitely have available slots. I'm always challenged when someone says, do you want someone in particular? Because I look for people from every industry.
Mm-hmm.
And because I have multiple CE groups, chances are that if there's a conflict in one group, I'll have an open seat in the other group. So it's really more about the mindset of the people. I look for people who are open to learning or open to growth. And are really willing to share experiences and help one another.
Wonderful. And I want to tell everybody that we are going to be sending out the replay to this with contact information for Jeffrey and Brad as follow-up. So look for that email. Great. Thanks, Jeffrey. And glad that we aligned here with Brad. Brad, what do we need to know about CTA?
Oh boy, how much time did you say we had when we started this? Well, all right. Well, first of all, you did mention hot topics, and this definitely is a burning coal for sure. Not only for our particular client base, but I think for most businesses at large. And just one quick shout out to Vistage. I speak to Vistage throughout the country, and even though Vistage themselves is really catered towards business owners and their key executives, when I present this topic, everyone kind of is a bit shocked as to its need and its overbearingness. So one of the benefits I think that you get with being in an organization like Vistage is that you do have professional speakers like myself who come into the organization and really bring awareness and top of mind issues, business issues, legal issues, financial issues, health issues, structuring, finances. So it's definitely, this is just kind of, I think, a small, as I say, tip of the iceberg experience that someone may get if they happen to be interested in joining a Vistage group. I've been involved in Vistage myself for well over 15 years. I started out in a key executive group and kind of made my way into my own CEO group. I think it's a wonderful organization. I feel very privileged to be one of the speakers for Vistage, and I definitely encourage anyone who's interested to reach out to Jeff and his organizations. I think it's a wonderful, wonderful organization, and it's well worth the investment of time and money. Okay, so with that being said, Paul, can I share my screen? Because I think the best way to do this is just kind of walk through. Sure. I only have 6 slides. It's not a very large presentation, but I think it's chock full of information. And having delivered this, as I mentioned already, in several Vistage speeches, I kind of know what's the main key takeaways that most people need to get to give them enough information where they can explore this with their existing professionals or to seek out other information. So, Paul, if you can let me.
Yeah, you should be fine to share now.
Okay, here we go. All right. So I think one of the most important things to know, first of all, when you're talking about a new federal law, let's first explain what it is, right? I think that before we get into the, as they say, before they get into the weeds, let's just take a big look at the forest at large. And let's take a look at the name, because I think the name itself says a lot about what it's trying to accomplish. This is called the Corporate Transparency Act. And what I like to say, what does that mean in plain English? The Corporate Transparency Act. Well, like any word, transparency seems to be a big buzzword now in the political environment. And here it found itself in the CTA. And what I like to say in plain English, very simply, who is the person behind the veil? That's it. CTA is a fancy way of saying who is the person behind the veil. And the difficulty that people have, but people realize that you want a degree of privacy. And although that is incredibly challenging in today's modern society, the way that people get privacy is by putting together entities, or maybe even a series of entities, and maybe even filing these entities in certain jurisdictions that respect privacy and disclosure more so than others. And so they're trying to get a degree of privacy. Not only does it help them in their own business dealings from being readily apparent on who's who on public records, but it also presents a challenge for the government to find out who's the person behind the veil. And there's no need to go back in history, but you can look from 9/11 to Sarbanes-Oxley to all kinds of different events that have taken place over the last 20 years, where the government is always trying for regulatory purposes to find out who are the people that are owners, who are the people that are the substantial decision makers, who are the people that are moving the needles to make decisions that may have possibly adverse tax or adverse consequences. We're going to call that bad actors as an entity. What entity is a bad actor? And who are the people, who are the brains behind that bad actor? So if you understand what the government is trying to do, they're trying to create a database of all the entities that are out there, roughly about the estimates between 32 to 35 million and growing daily. They're trying to create a database of these entities and who the people are behind the veil of those entities. So if you understand what the CTA is trying to accomplish, the rest of this is just going to be, it's just going to be, what do you call it? Extra, right? It's going to be just extra commentary, as we say. So there's two parts to this. One, who's the person behind the veil if the company is deemed a bad actor? And most importantly, number two, from the government's point of view, where do we show up to put handcuffs on the people behind the veil? So two things. Who are the people behind the veil? And if that company is deemed a bad actor, where do we show up to put handcuffs on the people making those decisions? The owners or the substantial decision makers. If you understand the government's objective, who are the people behind the veil? Where do we show up and who do we put handcuffs on? Now you know what the CTA is. This is a law enforcement tool. This is a government database being created by FinCEN. And FinCEN is an acronym which stands for Financial Crimes Enforcement Network. So it's a criminal enforcement network, part of the U.S. Department of Treasury. So it's a law enforcement database. Who are the people behind the veil? Where do we show up to put handcuffs on them if they're deemed a bad actor? And that's what the CTA is. It's being challenged constantly. That's one of the I just added a couple of slides this morning because of this, as from some of the pushback that we're getting as advisors and some misinformation I think that's out there in the general population. But if you understand the overall arching purpose, then I think the rest of this is that's going to be very simple to take place. So the first important thing to note is that this became effective as of January 1st, 2024. So this is the current law. And this is one of the things, as I mentioned in my opening statement, is that I go to business owners, not only my client base, but also when I travel the country to other Vistage organizations who are business owners, they're like, I've never even heard of this before. Well, guess what? We're already into what is today? April. It's actually today is a tax day, roughly around mid-April. And guess what? This has already been in place for over 4 to 4.5 months. This is the law. And so what it is, it started back on January 1st of 2024, where you have to create what's called a beneficial ownership information report must be filed using an electronic filing system with the FinCEN. There it is, Financial Crimes Enforcement Network, which is a bureau of the U.S. Department of Treasury in their secure database. Now, one thing I will mention is that for all intents and purposes, to the best of my knowledge, this is a secure database. Many people are saying, well, I'm trying to protect my privacy. If I have to give all this information, which we're going to get to in a couple of moments, if I have to give all this information to the government, am I breaching my privacy? Is this going to be, I put all these things in place to kind of protect my privacy, and now am I going to open up myself to the public records, to the country and world at large? And the answer is no. For all that we have information that this is a secure database only available for law enforcement and law enforcement purposes. It's not like you can just go onto Google and type in who is the beneficial owner of this, absent that information already being part of public records. And
So
a
Brad,
lot
they're
of
probably
that
sharing it with other agencies and so forth internally.
Yeah, there are. And we're going to get to that in here just a moment. So let's kind of get back down to the purpose. And I really couldn't come up with a better explanation than what I have right here in this paragraph. So CTA is aimed to hinder. There's the word I'm using, bad actors. And who are the bad actors? Those who seek to conceal their ownership of corporations, LLCs, or other similar entities like limited partnerships, for example, in the U.S. in order to facilitate illicit activities, including money laundering, the financing of terrorism, proliferation of financing weapons, serious tax fraud, human and drug trafficking, counterfeiting, piracy, security fraud, financials, and it goes on and on and on. So you can see this is really geared towards a financial crimes target, and that's why they're creating this law enforcement-based database. What's important to know are these dates. So when you have to file this report, this is called the beneficial owner information report. So these are very important dates because companies existed before the effective date. That means that before the beginning of this year, 1/1/24, and there are companies that have been formed since 1/1/24, now 4.5 months into the year. The timelines are different. So we need to know, where are you holding? Are you pre-2024 or post-2024? Because what's information required to be posted and the timelines you have to submit this information vary. As I already mentioned to you, that we're looking at between 32 to 35 million companies pre-1/1/24 that have to now report. So you can imagine the government's going to give us a little bit of time to try to get all these entities into their database. And so this is what the first bullet point says down here. For non-exempt entities, that's also important because the government also has listed out 23 exemptions. There are 23 exempt classes of entities, of companies that do not have to report. And we'll get to that in just a moment. That may have existed before January 1, 2024. So if you were one of these non-exempt entities, which by the way is the substantial majority of them, it's 23 exemptions, and most people do not fall within that exemption, have to file this by January 1st of 2025. And if you look at those dates and you kind of subtract the difference, you'll notice they're giving us 1 year. We have 365 days since January 1st of 2024 to input 32 to 35 million companies into this FinCEN law enforcement database. As you talk about an overwhelming task, it certainly is. We're hoping that maybe we can get an extension of time. I believe there is some discussions in Congress about maybe having a small extension of time, but as of right now, we have this 1-year window to get 32 to 35 million companies that all existed before 1/1/24. Now, I'll spend a moment here and just talk about non-exempt. I'm not going to go through all the exemptions. If you're curious, you just go on to fincen.gov and you can get a full list of all the exemptions. But there's two that really kind of kick in as far as that affects most of us and most of my client base. The other 21 or so are all entities or types of entities that are already subject to reporting within their own industry, that the government already knows who's behind the veil, right? So for one example is banking, right? If you're running a bank, right? If you're a Bank of America and you're running the bank, there's so many reporting obligations through the banking industry and governance that they already know all the decision making. If you have a nonprofit, they already know because of all the filings you have to make who the people are behind the veil. So they don't need additional sources of information because that information is already readily available to them. So that's about 21 of them. Governmental entities, banking. If you're running an insurance company, you're running I believe it's maybe like an accounting firm. There's all kinds of information that's available that there's no need to disclose. Now, the two that impact most of our clients really are those that are large businesses. Actually, let me put a pause until I get to the next slide because that's going to be relevant. But let me kind of get back to our timeline here. So sorry to kind of skip around on that. I want to make sure at least we covered that there is a class of non-exempt entities and exempt entities. So we've already discussed that all 32 to 35 companies that existed before 1124 have 1 year to file. And then for those that existed that are non-exempt from January 1st moving forward, that means you have a filing date with a Secretary of State somewhere, January 1st, 24, or basically thereafter, you must submit this BOI, beneficial ownership interest report, within 90 days of creation. So there you can see you have two different timelines. If you were before 1/1/24, you have 1 year to submit your information. If you were formed after 1/1/24, you have 90 days. Now, one more important timeline to pay attention to is what if you made an error in it? What if something happened? What if there was a change? So you went ahead and you filed, like most of my clients, we knew this was coming down the pipeline. So as of January 1st, 1/1/24, we went online and we filed a whole bunch of these, and we continue to do so. But then someone comes back to me and says, listen, I'm sorry, I misspelled somebody's name. Or this person has moved, or this person has passed away. Now this person inherited their interest, or this person exercised a stock option. Now they have more interest than what we reported before. These are all changes, and there's a list of these changes. Now they have only 30 days to report once that change took place. So we have three very important timelines. You have the pre-24, 1 year, the post-24, 90 days. And then once you filed, if there's a change, you got 30 days. Okay. So if you're all not readily confused yet, that's at least it's all there. I try to highlight the important parts to you so at least you get it.
And if you don't hit those timelines, you're going to get into,
You're gonna get, that's right. We're talking about penalties.
Yeah, lovely.
Okay, so now what is a reporting company? So we got to first go back and say, well, who does this even apply to? So we were talking about a company, and who is a reporting company? So the first thing you have to ask yourself, are you a reporting company? And also, so the first thing is any entity that was created by filing a document with a Secretary of State or similar office or territory or Indian tribe. And so most corporations have an article of incorporation. LLCs, articles of organization, limited partnership, articles of limited partnership. These are documents that are entities that are created by filing a document. But what if you're operating as a sole proprietorship? Hey, I just decided I have a DBA, I have a bank account, but I never filed any kind of articles. I'm not an LLC. I'm not a limited partnership. One, even though you have a DBA, ABC tool company, you are not an entity or not a reporting company because everything is flowing through to your individual tax return. The government already knows who you are. There's no veil that you're hiding behind. A DBA is not an entity. It doesn't have its own EIN number, right? It doesn't have its own filing. It's just you acting under a different name, and they already know who you are. So again, there's no veil, so there's no need to report who's behind the veil. So the first thing the first box you got to tick is, did the entity in question file a document to be in existence with a Secretary of State or similar U.S. territory or tribe? Now, if you did, here's our 23 categories of exemptions, and they're all listed downside there. But the one that applies mostly to ours are large operating companies. This is basically, Jeffrey, you can even mention this. You even started out by saying that the average business has a gross revenue of 23 million up to 200 million. That was kind of what you started off with. So here we go. Do these people qualify as large companies. If you qualify as a large company, here again, the government says you don't need to file because we already know who you are because you breached these particular these particular benchmarks. So the first thing is you have to have more than 20 full-time employees. So if you have more than 20 full-time employees, and full-time again is defined by the U.S. Labor Department, and you've reported $5 million or more in gross receipts between the company and maybe some of its subsidiaries in the aggregate, and you have a physical presence in the United States. The principal operating location, the PPB, principal place of business, is located in the United States. If you click all three of those boxes, you are not a reporting company for purposes of the CTA.
Brad, can I ask you a question here that comes up?
Yep.
Yeah. So, and we're with some other chairs, and Jeffrey, you may even want to chime in here, is that the immediate response when seeing this is a couple of chairs said, hey, none of my members are going to be impacted by this law because the companies are too big.
Right.
But then as you start getting into how you advise these members to set up their companies for asset protection purposes, you know, there's carve outs, brother-sister relationships for IP, maybe trucks involved in the business. And all of those could be impacted by the law. So it's not necessarily true just because the company
Right.
is, well, how would you
Right.
speak to
Right.
that?
So thank you, Paul, because because the a company in question is not a reporting company because it falls under the large operating company exemption, doesn't mean you as an owner are now exempt. Because Paul, you're right. Our clients could have an operating company. They could have a real estate company. They could have an IP company. They could have their own stocks, bonds, and company. They could have a couple of rental properties out there. They could have a little side hustle over here. So just because large company number one is exempt doesn't make you exempt. All the other companies are now subject to CTA unless they fall under one of the exemptions. So just because one company is exempt doesn't mean everything else. However, if the parent company is exempt, all the subsidiaries that make up that company are exempt.
Jeffrey,
Right?
do you see that with the big companies you're dealing with, multiple structures going on? Does that come up?
I'm sorry, I was muted.
Yeah.
Yeah, I do see it with a few of my members, not with all of them.
Yeah, because some of the point of confusion is that if the parent company is exempt, all the subsidiaries are exempt. Got it. But just because parent company is exempt, but you have a small LLC that has a rental property, that's not exempt, right? That has to be tested on its own. So this is the one thing that I wanted to clarify, because what if you only have 19 employees, but you do have 5 million more in gross and you do have a physical presence in the United States? You're not exempt because you don't have more than 20 full-time employees. So you got to be very careful on how this is interpreted. So you have to have all three. It's in the conjunctive. That's why I put the ands in bold over here. It's more than 20 full-time employees and 5 million in aggregate gross receipts and physical presence in the United States. If any one of those are missing, you can have $1 billion, but it's only 15 employees. Then you are a reporting company. So that's kind of like checkbox number one. Are you a reporting company? Now the question is, now that you are a reporting company, who is now a beneficial owner of the company? So now you have the company itself. Now, who are the owners? Now the government says, okay, I got a company. It's a reporting company. Who are the people behind the veil of that company so I can show up and put handcuffs on them? Who are these people? Who are the ones that we care about? So you can see here the CTA defines a beneficial owner as a natural person who directly or indirectly, et cetera, or exercises substantial control, owns more than 25% of the equity in the company. So that sounds pretty simple and straightforward. If you have 25% or more ownership in the company, then you are a beneficial owner and you have to report as a beneficial owner of a reporting company under the CTA.
Brad, Jeffrey has a question. Jeffrey, you want to ask that, Brad, now that we're talking about it?
Sure. The question, Brad, was if a company hovers around 20 employees, sometimes 19, sometimes 22,
Yeah.
Are they better off just doing the filing so they don't have to worry about what their employee counts are?
Yes. So the general rule in this space, but myself as general counsel, and I think in everywhere that I've also learned among my colleagues, is error on the side of caution and file. When in doubt, file, because the consequences of not filing, we're going to find out, are quite dramatic. And so error on the side of filing. And you'll find out that it really isn't all that difficult to file. It may be difficult to get the information to file, but you'll see. So there's two very important parts here. If somebody directly owns 25%, or they exercise substantial control, that's where things get a little bit muddy and difficult. Because if you have a company, say for example, the three of us own an LLC, you got Brad, Paul, and Jeff. We each own the LLC a third, a third, a third. Well, we have a reported company, we have an LLC, filed in articles of organization, and we each have a third, 33.33% ownership membership interest in the company. Well, 33.33% is greater than 25%. We all now have to file as beneficial owners. But what if we change the facts a little bit? What if there's 5 of us? Now we have an LLC that was a reporting company, and we all own 20%. We all have 5 of us that have equal ownership in the LLC. Now we got 20% apiece. Nobody has 25% or more. Does that mean that nobody has to report? There's no beneficial interest. There's no direct ownership of 25% or more. So the answer is no, there isn't. But somebody needs to make a decision. And typically in this example, when it comes to LLCs, you typically have a manager. So there may be 5 owners at 20% apiece, but there's only one manager. Brad's the manager. And so since I'm the manager, I'm the one that exercises substantial control over the entity. Nobody else that has to report, but I have to report because I have substantial control, although nobody has greater or 25% or greater direct ownership. Change the facts again a little bit more to kind of show you the different flavors of this. What if we have an LLC? Same exact fact pattern, 5 owners, equal owners, 20% apiece. But rather than it being manager managed, the example I just gave you, one manager, what if it's all member managed? In other words, everybody has a vote in management equal to their ownership. So if you're member managed, nobody has greater than 25% direct ownership, but we all have an equal voice in substantial control. Now all of us have to report as beneficial owners. You kind of got that? So same exact scenario. An LLC, there's 5 owners, but only Paul and I are joint manager. So Paul and I have to report. But one last scenario. What if we have 5 owners and none of us we're all equal, 20% apiece, and then we have let's see, my father Harry, who is not an owner at all, but he's the manager. He has to report as the substantial decision maker, even though he has no ownership interest. So the challenge that we're having with our clients is trying to define this term beneficial owner. I'm getting all kinds of pushback. Okay, I'm not an owner that has greater than 25%. Everyone can kind of figure that one out. Beneficial owner, they think direct ownership of stock or membership interest or limited partnership interest, and they see 25%. But what they're forgetting is that there's a second prong to that. Mixed up in that definition of beneficial owner is this substantial control officer. And that would be typically your CEO, your president, your managers, your C-suite of people, all who have decision-making authority, okay, which can be deemed controlling officers, even though they're not owners at 1%. And then it gets one layer even more complicated when we get down to the next paragraph of trusts. Now, I can tell you that I've been doing this work for 25 years, both estate planning and corporate work. And every single one of our clients have been told or have worked with our office to make sure that their entities are inside their trust, their family trust, their irrevocable gifting trust, their spousal trust, their charitable trust, whatever the trust is designed to do. At some point in time, the entities are put inside these trusts. So now all of a sudden things change. Because right now, if I own it, if Brad owns a property, an LLC in an individual capacity, but I take Brad Holdings LLC and stick it inside the Barth Family Trust, now who's the owner? It's actually the trustees, which now includes perhaps my wife, right? And now, wait a second, there's also maybe somebody has the power to change that trust, which could affect the powers of the trustee. Maybe there's someone that's what's called a trust protector. And now all of a sudden they become a substantial control officer. Or maybe somebody has the power to change the distributions of the trust. We call them power of appointment holders. They're also fall under the category of substantial control officers. What about the beneficiaries themselves or the powers of the beneficiaries? Depending upon who they are and what they are, they may become 25% owners and or substantial control officers. So it's not, so the pushback that we're having as advisors is that they say, I have an LLC. It's just my wife and I. It's 50-50. We're both managers. Go ahead and just fill this out. It's easy peasy. But what they're forgetting, that when they're putting it inside their trusts, and our clients have sometimes some pretty complicated trust structures, asset protection, gifting trust, estate minimization types of trusts, et cetera, et cetera. When you start dropping these things now inside trusts, a whole nother category of questions come up. So who becomes the owner? Because you don't own it anymore, the trust owns it. And within that trust, we have a bunch of potentially different substantial controlling officers, and that all has to go through. Otherwise, you're reporting incorrect information to the federal government through this FinCEN beneficial ownership interest report. And then one last thing, as far as husband and wives are concerned, especially in community property states. I know this may be going out maybe to the country at large, so you have both a mix of community property state attendees as well as common law states. Well, in community property states, typically, if your name is on it, like it's the name of Brad Barth, but I acquired this particular rental property in Brad Barth LLC during marriage. Well, guess what? It's community property. I don't care whose name's on the thing, it's community property. And as a result, my wife is now a beneficial owner because she has actually 50%. So Brad has 50% and Bina has 50%. We both have greater than 25%, even though I may be the only manager, because as far as I'm concerned, on the operating agreement, it just shows Brad 100% and Brad manager. When it says Brad 100%, what that really means in community property land is Brad and Bina 50-50. So you have to think about that also. Maybe you're filing these forms, but you didn't account for the community interest or jointly held interest with spouses in common law states. Okay. Again,
and Brad, Jeffrey has a question too about a good question about a trust.
Yeah, I just want to get a clarification. If someone has a revocable trust to handle personal assets as opposed to a business asset, is that considered a non-exempt entity that has to report as well?
The trust itself doesn't report. Remember, the trust is not an entity created by filing a form with the Secretary of State. So although I'm talking about all these trusts, the trusts are not subject to CTC. Corporations, limited partnerships, LLCs, they are reporting companies. But when they wind up being transferred into a trust for probate protection, orderly distribution of assets protection or distribution, maybe second generational asset protection, estate tax minimization protection. We put them in a trust. The trust itself is not a reporting entity, but it becomes relevant because now you may actually have a change of ownership. You may have a change of substantial control. And guess what happens though, Jeff? What's happening is that clients, I told you, they have this 90-day window. If they formed an entity today, they have 90 days now to do the BOI report. So they come in, they form the entity on, what are we, February 1st. Now that had 90 days. So it's February 1st, 90 days, whatever that is. Somewhere, and then they file it. So now they think they're done. They filed it. It's in the name of Brad and Bina, done and done. But later, I come along and I move it inside a specialized trust, an asset protection trust. Now I have 30 days to report the new owner. the new limited power of appointment holder, the new protector, right? I have 30 days. I changed it. I filed it correctly, but I made a change by funding it into one of these trusts. And now I have 30 days. You see how this gets complicated, right? And it's
Absolutely.
yeah. And then one other thing that's for those that have filed in 2024 and moving forward, we got one more thing down here. It's called the company applicant. This is the person who directly files the actual form with the Secretary of State, who pushed the send button when they submitted the information to the SOS, or who told the person. And in our case, that's me, the lawyer. I tell my assistant, Ronnie, we need to form an LLC for Jeff. So not only do we have to do all the information for Jeff, and this happened post 2024, we have the reporting company, Jeff Holdings LLC, Jeff and his wife as beneficial owners. And now we actually have to put in Brad and Ronnie as the company applicant. The company applicant is not relevant for all the pre 2024. For the 32 to 35 million pre-existing companies, the government is saying, we're not going to require you to try to go back and figure out who formed this thing, because who the heck knows that? But from this point going forward, 1/1/24 going forward, we want to know who formed the entity. Because if we can't find the bad guy to put the handcuffs on, right, we're going to go to the lawyer who set the damn thing up for you, right? Or whomever that person is. So they're coming after the actual controlling officers, the actual owners, the substantial control officers, and the person who assisted you in setting up the entities. All right. So it's pretty overwhelming. Now, to your point, Paul, what if you don't do this, right? What if you decide not to comply, or just because you weren't aware of it, ignorance is bliss. You just didn't know, you didn't file. Well, on the record right now, it says there's a $500 per day per entity penalty for lack of compliance. That has been indexed for inflation. I believe that happened late February. So it's actually $591 per day per entity for each day of the violation, up to a maximum of $10,000 per entity. And on top of that, you could have up to 2 years in prison per entity for lack of compliance. So it's pretty draconian in what they're trying to accomplish. It's not, and I'll give the government its credit where credit is due. They made it pretty simple to do the filings once you figured out what has to be filed. The challenge is not doing the filing. The challenging is going upstream, as I just mentioned, to determine, one, are you a reporting company, or is there an exemption that you fall within? Two, if you are a reporting company, are you a beneficial owner, meaning 25% or greater, or substantial control officer, and a company applicant? And has there been a change? Like, what if someone passed away and you were only 10%, and now you inherit your parents' 90%? Well, you went from 10 to 100. Guess what? You now own more than 25%. You got to report. So all kinds of things can happen. You change address, you move cities. All kinds of things can happen that could affect changes. And now you have 30 days before this kicks in.
And Brad, so I learned recently, is this right, that the IRS is the one responsible for collecting the fees?
I actually, Paul, I don't know, but here's my guess. And my guess is that FinCEN is a I don't know what you want to call it, like a category, a subcategory of the U.S. Department of Treasury. And the U.S. Department of Treasury is also the main overseer department of the IRS. So it kind of makes sense that since you're under the umbrella of the U.S. Department of Treasury, that the IRS and FinCEN may kind of join forces to go after folks for this reason. And they kind of know, because every entity has an EIN number, an employer identification number, or a TIN number. And when we file the reporting companies, one of the things we have to put in there is the formal legal name as it appears on the articles of organization, and the company's EIN number. Now, date of organization, jurisdiction of organization, were you formed in Delaware, were you formed in Florida, were you formed in California? So the government knows which entities have been checked off. So maybe that's your crossover with the IRS for enforcement purposes. And the scary thing about this again, as I keep on mentioning this because the lack of public awareness is scary. And the consequences, as you can see on the screen, are pretty high. And ignorance is no excuse of the law, as they say. And I'll give a very simple example on how this can happen. So about a few months ago now, I went out to the mailbox and I got a letter from the IRS, and that's never good when you open up your mailbox. There's a letter.
Not a birthday card.
I don't think it was a birthday card. And I opened this thing up, and I myself have about 10 companies. And one of them said that you have a $3,700 penalty for making a late S election from back in 2021. First of all, I'm like, what is this? I said, and here it is in 2024. Gee, IRS, why couldn't you have told me earlier that I had a late filing and maybe to minimize some of those fees? I simply just dropped the letter onto my CPA, and she thankfully was able to get rid of it, and that was resolved. But it was an example to me of how this is going to happen. They're going to see certain EINs that don't have a corresponding CTA compliance. The ticker is going to start. And then when they get around it, maybe it took them 3 years to get to me to give me my late S election. When they get around to it, you're going to get a letter. Maybe it will come from the IRS with your penalties for lack of filing at currently $591 per day per entity. That's the scary part, Paul. You're going to go out to your mailbox one day, and most people didn't even know about this, right? So that's kind of a thing that we worry about.
Yeah, and I think they just hired like what 10,000 more IRS agents too, or something.
Right.
I mean, gearing up.
All right. So in the last couple of minutes before I guess we can open up for questions or whatever, I want to bring up this. This is the USBU, which is the National Small Business. I think it's a union. I'm not quite sure what that. Couldn't find what the U stands for. Versus Yellen, and Yellen, I think she's the one that's kind of heading the cabinet member in charge of the U.S. Department of Treasury. So we're getting a lot of pushback, and this is also causing some confusion. Hey, Brad, thanks for letting me know about the CTA thing, but it's currently deemed unconstitutional, so I'm not going to worry about it. Okay, that's probably the wrong direction to take, and it certainly isn't the advice that we're giving our clients. If you take a look at this, I think this is the Small Business Association, Small Business Union. The NSBU is an Ohio nonprofit corporation that represents and protects the rights of small businesses across the United States, which is comprised of around 65,000 members. Now, keep that number in mind across all 50 states. Now, the plaintiff asserts that the CTA and its disclosures are unconstitutional, and then they list a whole bunch of constitutional powers. The conclusion is that with the court's ruling, it was deemed unconstitutional as to these groups of people. That is, these 65,000 people. If you are a member of the National Small Business Union, whatever that U stands for, then you have a temporary injunction, the government from enforcing the CTA against you and only you. With the court's ruling on standing, and it goes on to say various items here, but basically what we're advising our clients that it seems very clear that Congress can make a very minor adjustment to the language in the CTA to make it again constitutional. So the areas that they were deeming it to be unconstitutional and they got the injunction can be very easily clarified with an act of Congress to now make it again constitutional. But for everybody else that's not a member of the NSBU, this is the law and it applies to you.
And Brad, I saw on the FinCEN site the government's already appealed it.
Already, of course, yeah, and every other challenge that's out there right now, the same advice goes to what I told you earlier, Jeff. Err on the side of filing. The information they have that they asked for about the reporting company, name of the company, where it was organized, what's the date, it's not all that. What's the EIN number, and then who are the beneficial owners? That's the analysis part. What's the person's legal name? Where do they live? Remember, not their corporate address primarily, but where's their residential address? Because where does the government show up to put handcuffs on you? Typically at your home address. They want some type of identification with a government issued number on it. For most people, it's going to be your driver's license or your US passport, valid, non-expired, currently valid driver's license or passport, among other government issued IDs. And they actually want a color photo ID of that. So they want your picture on it with that number on there, all that being uploaded into this FinCEN database. And this is what people are getting really upset about, because they're really giving a lot of information about the company, information about the beneficial owners, who they are, where they live, copy of your driver's license, copy of your passport, either one of those, along with a color picture of that stuff. So it feels very intrusive, and it certainly should be, because it doesn't seem to be the way that we operate in this country. One of the benefits of having entities is the ability to have a little degree of privacy, and it seems to be getting stripped away. But again, this is a law enforcement database, not a public access database. At least that's how it's being advertised. So. That's kind of, I think, the wrap up. Now, there are just one last couple things I want to mention. There's, as you could notice on the bottom right hand corner of all the slides, there's a company called CTA Filing Solution LLC. That's actually me. We actually put together a company at the beginning of the year, became effective 1/1/24, along with the CTA, where we're assisting our clients in doing the CTA filings for them. Some clients, especially our clients that have multiple entities, believe there's a benefit of basically outsourcing this compliance, and we're working with our clients to making sure we're getting all the relevant information and applying it to the appropriate FinCEN database. If there's any questions, we're kind of reaching out to make sure it gets done. And then through the law firm, again, this is kind of a different service, as that upstream analysis, Jeff, I was telling you earlier about, between ownerships and trusts and substantial control officers. That's a legal thing. That's not a filing service. CTA Filing Solution will file. You give it to me on the back of a napkin, I'll file it for you, right? There's no legal analysis there, simply a filing service. If you need legal analysis, that's where Barth Calderon kind of comes in as a law firm. And we're able to produce these beneficial ownership interest reports. We get the information from you, copies of the relevant documents, copies of trusts, et cetera, and we're putting together these BOI reports. Now, once you have the BOI report, Jeff, if you want to file it, go ahead, knock yourself out. Not that complicated. But most clients just say, listen, do the whole thing for me, do my analysis, and go ahead and give me the filings. Done and done. And that's kind of so those are two different services coming from two different entities. The analysis is from Barth Calderon, the law firm. The actual filing is from CTA Filing Solutions, LLC. And both of those are up and available to most of our clients. All right, so with that, I'll kind of hand it over with our last 10 minutes or so to Paul and or Jeff, or anyone any questions or comments that may come through the audience.
Yeah, I'll start, and Jeff, you can jump in if you have any too. But Brad, what if you've got like I know at the law firm there's plenty of clients where there's multiple owners. They've got a report. I think of the franchise businesses and there's investors and all that. What if somebody says, no, I'm not reporting, or you can't find somebody, or or they just won't do it, or they're older and they don't get it. I mean, who's responsible for the fees and everything?
Yeah. Oh my gosh, Paul, that's such a great question. And 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 I have a very crummy answer for you. As a matter of fact, if you even go on to the FinCEN's websites, in their most recent edition of their FAQs, their frequently asked questions, that exact point is addressed. And how do they address it? By not addressing it. They simply just say it's the reporting company's obligation and responsibility to have all the information readily available to comply, so the reporting company can comply with the CTA. That's the answer that they're giving. They're basically just kind of pushing that onto the reporting company. And Paul, I don't know what the answer is, because you can't report inaccurate information. And if someone is being a stick in the mud, or you simply just can't locate them, what do? You can't fill the information out and pushing a button under penalty of perjury that this represents all the beneficial owners of the reporting company, when in fact, it doesn't.
Yeah.
I don't have an answer for you. Thankfully, I so far haven't come across that, but it's definitely been a conversation piece. What I'm doing, and I think it's the only thing I can do, is really put that obligation back on to the client owner of the company. Listen, I know you hate your brother-in-law. I know you hate your partner's spouse, and they hate you too, by the way, but I really need to get this information from them. Otherwise, we really can't move forward.
Yep.
I don't have an answer for you, Paul. I don't know.
No, understood.
And this
Jeff, you want to handle that
all
question?
and this
Yeah.
all runs into the constitutionality issue that comes up. People who want to comply can't. They can't comply because they don't know all the upstream analysis. Not to their fault. They're not trusting estates and corporate attorneys.
Right.
They can't comply because the person they need to get the information simply won't give it to them, or they can't be located. I don't know what the answer is.
Jeff, there's a question there. You want to read that one? You see that one? You're on mute. Oh, there you
I'm
go.
sorry, I keep doing that. What if there are three founding partners, but only one of them owns 25% or more of the company? Can we report with the one founder who owns more than 25% shares of the LLC?
Right. So that goes back to the example I gave previously. The answer is yes. First of all, the one that has the 25% or more, they for sure, because they have direct ownership. That goes back to this slide here. They have direct 25% ownership. Whoops. Right here. But those other individuals, are they also substantial control officers? So even though those other individuals may not have 25% or more direct ownership, are they also managers of the LLC? Do they have substantial control? Again, and that's defined in the FAQs if you want to see that. As far as those are they substantial control officers? So they would have to comply with the BOI report as far as the disclosures, even though they don't have 25% or more because of their status as a substantial controlling officer. Right? Yeah.
Thank you.
Yeah. Yeah. This is the difficult part about this.
And Brett, my understanding is that FinCEN won't even accept any filings unless it's complete, right? You can't submit something partially. You've got to have everything ready to go. Is that true?
I actually I don't think that's the case, because we've done the filings, and it's not asking you the percentages. It's not asking you any of that information. It just asks you beneficial ownership number 1, BOI number 2, BOI number 3, add another, BOI number 4, add another. They're not asking you BOI number 1 at 25%, BOI number 2 at 35%. They're not asking you that. They're just asking you who they are, and that list can keep on growing and growing and growing. So I don't know how the government would know whether the list is complete or not. It's not like you have a number of shares that has to equal 100 at the end of the day. It just has BOI 1, BOI 2, BOI 3, BOI 4, and just the numbers keeps on growing. And when you hit done, you hit done, and that's it.
Yeah.
One thing I will point out, though, I don't think I mentioned it. There is one thing that the government has done to kind of, one, help protect the client's privacy, and 2, make filings a little bit easier. And this is something that's called getting a FinCEN identifier, FinCEN ID. So as I just got done telling you, we're doing a lot of filings for our clients at CTA Filing Solutions LLC. Well, you may say, well, gee, Brad, if I want to give the government all this information, why the heck do I want to give it to you? And guess what? I don't want your information either. I don't have all the securities and blah, blah, blahs. I worry about data breaches just like everybody else in the world. So you go online and you put in your information, your address, your driver's license ID, and you upload your driver's license all at home. Then the government will issue you what's called a FinCEN identifier, or FinCEN ID number. Now, that number is used for everything. Now, I would say, Paul, please get and give me your FinCEN ID. And I can't get that for you because it requires emails and phone calls and double, triple verifications. The government is trying its best to keep the information private. But once Paul has that number, think of it as this is his corporate social security number, right? It's your number, Paul, for life. And every time that we have, and Paul, you own 5 companies, every time I have to plug in the beneficial owner of these 5 companies, I just put in your FinCEN ID number. I don't even put in your name, Paul Hitchcock.
Oh, okay.
Show up.
Okay, nice.
Boom, 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 boom. And as I form a new company for you, Paul, and I have to file a new CTA filings, I plug that in as well. So I have an entire database of our clients' FinCEN IDs. So when we're
Got
doing
it.
the filings for you, I'm telling the client, you need to get the FinCEN ID. I cannot get that for you. But once you get the number, give me the number, and we keep that in our database, and we use that for all the filings. Only have to get it once, and that's the number that needs to be updated based upon, hey, you got married, you're no longer Paul Hitchcock. Well, it wouldn't be the case with typically with the, but like a lady owner, right?
Yeah,
Maybe
yeah.
would change her name, legal name or otherwise, right? They change the name, they change the address, they move. You need to update that FinCEN identifier. The number doesn't change, the information behind the number changes, and that's how we do that.
Got it. Jeffrey, there's a follow-on question there.
Yep.
There is. This goes back to the question we asked a few minutes ago about the 25% ownership in an LLC.
Yep.
They are not technically a manager. Only majority owner is a manager. What constitutes a substantial controlling officer?
Well, in that case, it's going to be driven by the operating agreement. But typically, if it's a manager managed LLC, which it sounds like it is, certainly they have the individual that owns 25% direct ownership, they have to file. And if that same person is the sole manager based upon the operating agreement, and it will say all managerial authorities are vested solely in the name of the manager, that's typically what you see in these things, then they don't have to, there's no second, oh, I got to file again as BOI number 2 as manager. Nope. They only had to file the one because they fit both categories. They are both a beneficial owner based on 25%, and they're concurrently wearing the same hat as manager, that is the substantial controlling officer. So you only file them, that is their FinCEN number, once. But if any of those other 20% or 25% or less than 25% owners, if they also are manager, then they have to file, right? Unless so there could either be one, answer the question, Jeff, that typically it's in the agreement itself that will define who the managers are, or you can have some type of internal minute, like you have corporate minutes. You could have basically LLC managerial minutes that delegated certain authorities over to other individuals, and depending upon what those authorities are that were delegated, that may rise to the level of substantial control officer. Don't know until you take a look at it. Right.
Right. Well, a couple of questions that come down to that is an operating agreement required? If not, then how would they know? There's no
That's
operating
right.
agreement.
So when you look at, the OA is not required, but a filing of the articles of organization is required.
Oh, okay.
And when you file the articles of organization, it's going to say right in there, every state has it. Are you filing as a member managed or as a manager managed? And then, like, for example, in California and other states, you'll have what's called a statement of information. There'll be a piece of paper where you're filling in all these people in their capacities. Who are the members? Who are the managers? What's their address? So even though you may not have an operating agreement, there's going to be some evidence as to who these people are. And depending upon how the articles of organizations were filed, member managed or manager managed, then you would know whether you have to file. The OA is not required, although extremely highly recommended. But if you don't have it, doesn't mean that you'd all of a sudden become exempt from the reporting under the CTA.
Got it. Now, in that case, if this person who owns more than 25% is putting it in their living trust, so to avoid probate and everything,
Right.
which is right thing to do.
That's the right thing to do, right? Mm-hmm.
Now you got to look at the trust, right?
That's right. That's right. Yeah, well, for sure. If this individual also was married, remember that 25% is actually owned by him and his spouse,
or her,
right? So
yeah,
the spouse, right? Exactly. So you have to worry about that. Then you have to look at who the trustees are. You got to look at, again, are there anyone that has what are called limited power appointment? We'll call it power holders. Are there trust protectors? We put trust protectors in almost all of our documents. I would say a good substantial majority of them have protectors that are not necessarily, and they're not family members, and they're not beneficiaries or subordinates. So you got to look for those types of individuals. You got to look at the powers that the beneficiaries hold. Most cases, Paul, not to overly complicate this, in most cases, husband and wife forms an LLC for the rental property. They put the property inside their family revocable trust. Trustees are them, beneficiaries are them, and it's all just the same